Welcome to Environmental Law course. In continuation to our discussion about the dispute redressal mechanism, environmental dispute redressal mechanism provided under the National Green Tribunal, we have tried to see that what were the genesis and the background of creation of the environmental court and how the Indian judiciary time and again repeated the demand for creation of green tribunal or the green court or the environmental court to look at the complexities of the environmental dispute and to dispense environmental dispute in a more amicable way where the end of the environmental justice can be served in a better way. And in this direction, we have noted down some of the effort which have undergone in India, meaning thereby the National Environment Tribunal Act of 1995, National Environment Appellate Authority Act of 1997, and National Green Tribunal Act of 2010. In the last lecture, we have tried to see that what is National Green Tribunal, what is the scope and ambit, what are the functions and powers, and how the National Green Tribunal happens to be a kind of a novel addition not only in matters of environmental dispute redressal mechanism, but as a whole in country's entire system of what we can say is the tribunalization of justice. And in matters of tribunalization of justice, how the tribunalization of environmental justice has been laid down under the salient features of National Green Tribunal Act. This is the inquiry that the tribunalization of justice, meaning thereby, as we say, after its enactment of in 1911 till today, the 14 years of functioning of the National Green Tribunal 2010 has altered the entire process of the environmental justice coming out of the pale and bounds of, pounds and shells of the adversarial process of justice and try to create a kind of a new jurisprudence of environmental dispute redressal mechanism. We see that over the last 3 decades, the Supreme Court had meticulously evolved the right to environment protection, and it called for some kind of the adjudication of environmental dispute beyond the traditional methods. And in that sense, the salient features of the National Green Tribunal Act 2000 Act try to have its specialized version of the court having spread over to 5 jurisdictions in India, and we see that the entire question of the environmental dispute adjudication, redressal and resolution has been addressed, and the preamble to the act have given its vision and focus and the basic foundational principle which we have just taken note of. Now we are going to see that how the National Green Tribunal 2010 is going to be established and what is the composition of the tribunal, what are the qualification and appointment of the chairperson and judicial member, how the chairperson, judicial member, expert member are to be appointed, what is the term. So the entire question of the administration of the National Green Tribunal, which has been mentioned under chapter 2, is which talks about the administrative aspect of establishment that deals from section 3 to 10, and we see in chapter 3, which is important, which talks about the jurisdiction, power and proceedings of the tribunal. So from our point of view, chapter 3 is very important and a very long chapter which consists of section 11 to section 25, and it requires a careful perusal to understand the very functional ambit of the National Green Tribunal 2010, and in that respect we see that how the tribunal is going to settle the dispute, how it exercises its jurisdiction, how it bars the jurisdiction of the civil court, and how tribunal is going to settle dispute relating to environment, and most prominently that the heart and soul of this act, that is called National Green Tribunal, appears to be what we can say that article section 15, which has given rise to Article 15 of the Rio Declaration, and it talks about something about relief, compensation, and restitution. And this is a clear departure in the entire dispensation of environmental justice from the previous cases and the preceding cases, that National Green Tribunal adopt a kind of the mechanism to have a detailed system of the providing relief. It also tried to have the compensation. It also tried to have the restitution. Thus, we can say that the Section 15 is having a therapeutic perception of the environmental justice, and this therapeutic perception of environmental justice, which was lacking in India right from the Bhopal case till this date, that the victims of the pollution, how they are going to be treated, how they are going to be redressed, how they are going to be compensated, how their rights are going to be enforced, that Section 15 of the National Green Tribunal act as a bulwark. Then we see that the appeal to tribunal and liability to pay compensation, so we can club together the Section 15 and Section 17, and finally we see that what is the procedure that is going to be adopted, and how the decision of this court, because this is a tribunal, and tribunal, as we see that under the constitutional scheme, Article 323A and 323B deals with the constitution of the tribunal under the Constitution of India, and a perusal of the constitutional provision, we see that it is not going to alter the very role as a paramount fountain of justice of to act to be acted by the Supreme Court. Rather, this tribunal, either it is given under Section 323A, National Administrative Tribunal, or the other tribunal which has been created by way of amendment in the Constitution of India, that must be perused, and that should not be forgotten, that this tribunal is something very parallel or something over and above to the Supreme Court. So, what is the mechanism of appeal in consonance with tribunalization of justice? And we try to see under this chapter the core provision, which start from Section 15, Section 14, 15, 16, and 17. So these four procedures are very important in this respect, and in this respect, what we see that the penalties are provided under Section 26, 27, and 28, and certain miscellaneous provisions are engrafted under Chapter 5th, and it goes up to Section 38. So we see a law which consists of 38 section and 5 chapter. So 38 sections and 5 chapters of this law, how it is going to alter the entire landscape of environmental dispute resolution in this country. We will be looking especially these 4 sections, Section 14, 15, 16, and 17, to have a panoramic perception of the entire mechanism of dispute redressal in the arena of environment. Dear learner and viewer, as we have identified that these 4 sections are very important, that is Section 14, 15, 16, and 17. Let us try to peruse Section 14, which talks about tribunal to settle dispute. And while saying that tribunal to settle dispute relating to environment, it envisages that the tribunal shall have the jurisdiction over all civil cases. So by one stroke, it tries to see that all civil cases comes under a jurisdiction where substantial question, this is a kind of a word which has been used either in Article 136 of the Indian Constitution, which talks about SLP, that when a substantial question of interpretation is involved, the Supreme Court, by way of a special leave, will hear the case and the appeal. So in this case, some kind of the intimation, some kind of a reflection, we see that all civil cases where substantial question relating to environment, including, and that question of environment is not only not concerned to the protection as it has been envisaged under Article 48. It is not only the question of improvement of environment, but going from protection and improvement of the environment, it tries to see the legal right relating to environment, and that is very important, which adopts the right based approach to environment is also given under this law to environment. So at one hand, it says that all civil cases involving substantial question relating to protection and improvement of environment and adopting a right-based approach and implementation of the enactment which is specified in Schedule First, and the Schedule First talks about environment, it talks about water, it talks about air, it talks about the biodiversity, and we see that the canvas and the ambit and scope of this law is being done under section 14 by settling dispute in a manner which will be entertained within 6 months from the date from which the cause of action of such dispute first arose, and it also provides the tribunal may, if it is satisfied that the applicant was prevented by sufficient cause from filing application within the said period, allow it to be filed within a further period not exceeding 16 days. So the idea here is to have the gateway of environmental justice wide open, and the intention appears to be not going to have a very strong or stringent measuring rod to look at the cases, but adopting a very amicable approach under section 14 of the National Green Tribunal Act, which try to see that what will be the mechanism of settling the disputes relating to environment. Section 15 is, as I have opined, that it says about the heart and soul of this act, which have taken resort to the Stockholm Declaration, taken resort to Rio Declaration, and it talks about relief, compensation, and restitution. So each and every words is having a wider connotation and import under in the case of dispensation of environmental justice. It has been suffice if it would have been said that relief and compensation, but to leave nothing to the chance, it has tried to encompass all these three things: relief, compensation, and restitution. And then section 15 says that the tribunal may by order provide relief and compensation to whom? The victims of pollution and other environmental damage arising out of the enactment which has been provided under Schedule First, meaning thereby all prominent environmental laws are made applicable, and we have the 5 major environmental laws dealing with the protection and improvement of environment. And it also talks about that this is very important because the whole nuclei or whole epicenter of this law is going to be the Bhopal case, and once it is the epicenter of all kind of adjudication of dispute, be that M.C. Mehta versus Union of India, be that the Professor M.V. Naidu versus Andhra Pradesh Pollution Control Board, and that's why we resonate the sound of handling hazardous substances which are provided under section 2D, section 2E, and the Factories Act, including accident occurring while handling any hazardous substances, is that the shadow of the Bhopal looms large on the entire question of purview and pale and ambit and scope of section 15, which talks about relief, compensation, and restitution. And here also we can see that the restitution of property is also included besides the environmental damage. So these are very important and salubrious provision which was engrafted into section 15. And while it talks about not only having payment of compensation for victims of pollution on one hand, environmental damages on the other hand, it tried to restitute, and doctrine of restitution means that that thing has to be brought in its original position, and it also talks about restitution of environment. So restitution of environment, restitution of property, and compensation to the victim of pollution, compensation to environmental damages, and compensation in case of the accident arising out of the hazardous substances are something which are very notable. And as I have reflected upon that this question, then relief and compensation and restitution of property and environment refer to clause A, B, C of subsection 1 shall be. Then what we have reflected earlier about the Public Liability Insurance Act in the earlier lecture, and we have tried to impress upon here that section 15, leaving nothing to the chance and confusion. It says it is in addition to Public Liability Insurance Act. So whatever compensation is being envisaged and envisioned under the Public Liability Insurance Act of 1991, it is not going to be in derogation but in addition to, and that is something very important as an overriding clause. Section 16 also talks about that compensation within a period of 5 years from the date of such compensation or relief first arose, and this is a kind of an embargo have been set. And it also say that the tribunal can have, if satisfied, was prevented from sufficient cause, then it can give some kind of relaxation. So it's a very pro environmental damage provision, pro environmental pollution victim provision, and that's why the court has adopted a very charitable, and the legislature has adopted a very charitable language in it, and that talks about that the bar of jurisdiction, because of the time, is not something which is to be strictly enforced into it. And finally we see that section 16, which talks about appeal to the tribunal, as we have seen the reference of the schedule 1 time and again. So what schedule 1 envisages and what schedule 1 here also tries to connote is being clarified with leaving nothing to the chance under section 16, which talks about the Water Act, which talks about the Forest Act, which talks about Air Act, which talks about Environment Act, which talks about Public Liability Insurance Act. So we see that the canvas of this law, that any person aggrieved by any order or decision made on or after the commencement of this act by the appellate authority, then they can go to directly to National Green Tribunal Act. Here I find the reference of section 52A of the Biodiversity Act missing, 2001, because that also empowers, and it has been mentioned under the Biodiversity Act that any person who is aggrieved by the decision of National Biodiversity Authority can go to NGT by way of appeal to the tribunal within 30 days, and which can be relaxed to 60 days. So a combined reading of section 14, 15, 16 gives a very panoramic perception of what is the mechanism of the dispute redressal mechanism under the National Green Tribunal Act. Having taken note of section 14, 15, 16 and try to see and gauge that what is the quantum and what is the nature of relief and environmental dispute, how it is going to be adjudicated, then we can pull out to the principle that what the procedure it is going to be adopted, that it adopts the procedure of a Civil Procedure Code for 1908, and it applies to Indian Evidence Act 1872. So whatever procedural mechanism has been taken by the Civil Code, and as it has been suggested under section 14 of the NGT, that it has jurisdiction on all civil cases, therefore it applies the Civil Procedure Code and as well as the Indian Evidence Act, especially section 123 and 123 of the Indian Evidence Act in regard to its procedure of summoning, discovery, production of document, receiving evidences on affidavit. These are being guided by two basic law, civil law of this country. Then section 19 also, while envisaging the procedure and power of the tribunal, also try to see that how it is going to review, issue the commission of the examination, witnesses, reviewing decisions, dismissing appeal, all kinds of the procedural wrangle which it is going to be adopted has been mentioned. And lastly, it says that all proceeding before the tribunal shall be deemed to be a judicial proceeding within the meaning of section 193, 219 and 228 of Indian Penal Code 1860, and thus it has also application of section 195 of chapter 16th of Code of Criminal Procedure Code 1973. Having this kind of a discussion, now what we try to see about the role of the salient feature of the tribunal is that it is going to be a kind of a law which is very important in the entire sphere of the environmental dispute resolution mechanism by considering its wide scope as it has been given under the Schedule First, which include all key environmental law such as Water Prevention and Control of Pollution Act 1974, Water Prevention and Control of Pollution Cess Act 1977, Forest Conservation Act 1980, Air Prevention and Control of Pollution Act 1980, Environment Protection Act of 1986, Public Liability Insurance Act of 1991, and Biological Diversity Act of 2002. So this is the ambit and scope which has been given, and the jurisdiction and the power of the tribunal extend to all major enactment on the environmental law. And we have seen the entire proceeding which has been discussed under the section 19 of the NGT vis-a-vis its additional role in dispensing relief and compensation apart from the Public Liability Insurance Act. Thus, we see there are certain cases, and as a pilot study of these cases from the National Green Tribunal order, for example, that in Almitra Patel versus Union of India in 2016, it imposed liability on the municipal corporation in regard to improper waste management, and establishing public bodies are not exempt from the environmental liability. And in Forward Foundation versus State of Karnataka in 2016, the NGT has directed for restoration of lake ecosystem and restoration of lake system, and imposed penalties on construction company for violating the buffer zone regulation, and it is again under Article 15 of the National Green Tribunal Act. In Manoj Mishra versus Union of India in 2020, in case of Yamuna rejuvenation case, where NGT imposed environmental compensation on municipal bodies for failing to treat sewage and extending liability to public authority for non-performance. In a similar manner, that in M.A. Ghafoor versus District Collector Thrissur in 2022, the NGT established a comprehensive framework of calculating environmental compensation. This is very important for illegal sand mining based on multiple factor and multiplier theory of the computation of the compensation, including the quantity extracted and ecological damage it has caused, because the illegal sand mining is a very common phenomena. Although it is appearing from the district collector Thrissur, but it happens to be all the river beds in the country are being excavated indiscriminately and leaving a big void in the entire river course in this country. So this judgment of the NGT of paying compensation and applying new models of multiplier theory in calculation of environmental damages and compensation is of far-reaching significance. Thus, we see that who can file the application. We see that any person who have sustained the injury, any person who is the owner of the property, any person who has a legal representative of the deceased, or any agent duly authorized by such person, or any person agree, including representative body and organization. Thus, this law is going to see that it is a public participation, meaning thereby this law is going to refer a kind of a semi-model of public interest litigation, because it has given a space to some kind of the organization to agitate upon if the person or individual are not coming to the doorstep of the court. Then it has recognized public participation, and it has tried to give more meaning and to read more from relaxation of the locus standi and public interest litigation under its power, that who can apply for an appeal under the NGT. Then what we feel that despite its salubrious provisions, what are the basic challenges which are being faced by the dispute resolution mechanism under the National Green Tribunal? We see that there are severe institutional challenges. Despite it has a large promises, it has some predicament, some pitfalls, some perils, and those perils are going to be slightly hinted under this slide, that it faces the institutional challenges, meaning thereby it has a very limited cooperation from the state and federal government, and it is marred by the poor in inspectorate and inadequate staff and the facility, and thus the court's wider role is often being falling short to its lofty ideals and objective which are set in the law. Thus we see that these are some of the factors which makes the dysfunctional character of the state administration and the bureaucratic inertia which it is suffering, especially the other organs of the ministry, and as well as the other ACLN and other satellite bodies which are involved in the task of protection and improvement of environment. Sometimes they are working in tandem, sometimes they are working in isolation, and that's why we see that some of the crisis also in the regime of carrying out the environment impact assessment because of appointment of unqualified expert committee member, and we see thus the provision is very novel and very overarching and have a great impact, but because of its practical application, we often find some regulatory authority or some expert committees are happens to falling short of the very objective. And we see that the amendment like Finance Act, which has curtailed some power, some kind of a finances of the NGT, tries to see that the ministry is very reluctant to see the emerging and the pivotal role in matters of finances, and therefore what we see that the NGT's expansion of power, which include judicial review and as well as the suo motu proceeding, which has generated some accusation and controversies, but it is to be considered in the interest and the larger interest of environment protection and sustainable development. But the challenges which it are facing are mostly the capacity building and the quality of the quasi investigation agency and its power and the character of the investigation under this NGT by the expert committee happens to be one of the major challenges. Then in order to address these challenges and to have a way forward, what we try to see that it has a multifunctional institution, and then it requires a kind of a balanced approach, which is very crucial in establishment of environmental justice and dispensation of the environmental justice to do away from the procedural bottlenecks and delay in disposal and abdication of tribunal's responsibility to other environmental agency. Therefore, what is required that there is a constructive external review and a periodic reflection, which are the hallmark of a any judicial institution. It requires some environmental rule of law and societal trust to see this act as a major institution of resolving dispute in this country. Taken as a whole, we see that the creation of the National Green Tribunal Act, which as an institution of dispute redressal has a great potentiality, and it has served a great void which India was having right from the Bhopal gas tragedy till 2010, and the time will only testify that how this green tribunal are going to meet the challenges of environmental pollution, and it will advance the cause of environmental protection, and it will also try to promote sustainable development. It will also try to adopt the right-based approach to environment, and how the tribunal is going to be very fair in matters of providing relief, compensation, and award of damages, and how the tribunal is going to act as one of the most sacrosanct organization in matters of environmental justice in this country. With this, we try uh, to end and conclude that the National Green Tribunal has come of age in heralding the sense of environmental justice in this country with by adoption of a multi-pronged approach to adjudication of environmental disputes in India. With this, I thank and I wish you a happy learning.